Hey everyone, it's Elhaze and welcome back to my channel. If you're wondering why it's been a bit since I've done a Don't Try to Make It in Music segment, I'm gonna link the TikTok below that explains everything. But I'm excited to be back and share with you everything I've learned about copyrights and why that's important to the music industry. Let's get into the video. So let's talk copyrights. Why am I doing this video now? There were probably other times that it made a lot more sense, around when Taylor Swift was dealing with the whole debacle and ownership of her recordings. Also, years back with Led Zeppelin and Stairway to Heaven. I actually had planned to do this years ago at this point. But here we are now, and it's still relevant, and I think especially helpful as I'm in the streaming space in addition to music industry now. And there's a lot of discussion around copyrights and why music can or can't be utilized on streams. So first and foremost, what is a copyright? It is the exclusive legal right given to an originator or an assignee to print, publish, perform, film, or record literary, artistic, or musical material, and to authorize others to do the same. But specifically for music, this means the legal ownership of a musical composition or sounds recording. This means any time music is created in any form and recorded, a copyright automatically happens. It does help protect you even more if you go out of your way to properly copyright. You can utilize a lot of sources to copyright your works, but technically once a recording is done, there is an automatic copyright with that creation. Okay, editing Leah, later on, I was going through the video and I talked about how there's an automatic copyright on your work when it's recorded. That is at least US law. I should have specified that we're talking about US law. But in addition, there's an automatic copyright when you compose your work. So when you create anything, there's an automatic copyright on it. But it is in your best interest to register with the Copyrights Office for better protection, because it's really hard to prove when you created your work if there is no paper trail. And because of this, it's important to note that in terms of streaming, and when you hear a lot of artists say, my work is copyright free, that's not entirely true. They're trying to let you know they're okay with you utilizing their work, but is the equivalent of an artist providing you with a license. They may not be asking for you to pay a fee, but they are providing you the okay for you to utilize their works. Every piece of work, every art, every musical format is copywritten just by default. So nothing is actually copyright free. They're just not going to claim you for DMCA. What are things that can be copyrighted? Things that can be copyrighted include that which is to be protected must be a work of authorship. It must be original, and it must be fixed in a tangible medium of expression. Fair use comes into play regarding copyrights because this is when a party is able to utilize a copyrighted work without the copyright owner's permission. This is due to criticism, comment, news, reporting, teaching, scholarship, or research. Parody as well, because it's transformative. This is how artists like Weird Al are able to parody any songs they feel without getting explicit consent from the original copyright owners of the song they're parodying. So let's talk about some things that make copyrighted cases so complex in terms of the court of law. So a jury of your peers in any court where a jury is utilized, are going to determine if enough of the new work is infringing on the rights of the previously stated work. And the reason this is extra complex is you typically are going to have a jury of your peers that are not well versed in music. They are not going to know things that are expected to be similar in works of music. For instance, amongst the same genre, there are things like chord progressions that are incredibly common amongst that genre. You may have an untrained ear that would think these are incredibly similar and therefore an infringement, when that is not the case. That is just how that genre typically has its works of art sound. And I want to make it clear that in no way do I mean to make this a discussion about whether or not jurors should be people of the general public. I'm not meaning to make a case for whether or not that works. I don't mean this to be a discussion on going against how copyright is determined in the court of law thus far. Just providing information for you that you may not have had. So what do copyright cases typically come down to? Well, it comes down to what percentage of the new work has infringed on the rights of the copyright holder. This means it can't just be that a chord progression is similar. You have to include things like lyrical similarities, motifs, vowel emphasis, melody, song structure. All of that plays a role in determining if it's infringement. It can't just appear to be similar, there needs to be more to it than that. Which is also why the juror thing isn't necessarily a problem, because they're given all this information. So let's talk about some cases over the last couple decades that have been really important regarding copyrights, and to provide examples on what that has done for copyright cases and providing precedent for all of us. So recently, Taylor Swift re-recorded a bunch of her works. This was able to be done without infringing on the copyright holder's previous record labels. This was able to be done because those rights that they hold only cover the recordings. That means the versions we've been listening to online prior to Taylor releasing her own versions are the parts that are owned and copyrighted by the record label. Taylor Swift still owns the rights to those songs in their existence, just not those recordings. Therefore, she's able to re-record these songs and these new recordings under a different copyright, being her own, providing her full ownership and power over these new recordings. While that wasn't a case, I think that was a very recent thing that happened that might shed light on things you maybe didn't understand if you don't know these things about the music industry. Another case from 1976. So the Chiffons versus George Harrison, one of the members of the Beatles. This had to do with the Chiffons song He's So Fine, which was done in 1963, and George Harrison's song My Sweet Lord was 1971. This case is incredibly important in showing that to prove infringement, you typically have to show that an artist could be reasonably believed to have access to the song that they infringed upon. He's So Fine was a well-known song and a big hit in its own right, and also George Harrison and the Beatles were known to cover many black girl groups during that time. So it is very, very likely that he had heard this song, and therefore more than likely that he infringed on this copyright. That's not to say that there was malice. George Harrison even said that this was unintentional in a hope that that would be some form of a defense. But it's not. It doesn't matter your intentions. You can still infringe upon the copyrighted work of another artist. It mattered that they had access to this work, because the only way to really infringe on another artist is if you had heard that work. A lot of things in music have been done before. Yes, there are changes, we go through different cycles, but there's a lot of recycling of different motifs, different chord progressions, lyrics, styles in general that are recycled, and therefore there are a lot of similarities. So you can't just have been determined to infringe on someone's copyright just because of the similarities. You have to have had the subconscious music in your mind when working on this piece. You must have had access to the piece that you've infringed upon in order for it to be plagiarism, in order for it to be an infringement. How many times do I say infringement in this? Another really big case that started in 2014, and this case stands out to me a lot because I was actually in college at the time this case was taking place, and I was in music history courses and business law courses where we discussed copyrights. So this was a really big case to me and one I really wanted to talk about. Spirit versus Led Zeppelin. So this had to do with the song Taurus by Spirit and Led Zeppelin's song Stairway to Heaven. The case started in 2014. It is an example of an incredibly long case and why pursuing things and even defending yourself in a copyright case can be so difficult. In 2016, it was ruled upon and sided with Led Zeppelin and determined that they did not infringe on the copyrights of Spirit. Spirit still fought this all the way to the Supreme Court, but in 2020, that's right, 4 years later, the Supreme Court finally denied wanting to hear the case, and therefore it was determined that the previous court's decision would hold and Led Zeppelin would remain fine with their copyright, and they did not infringe on Spirit. I heard a lot at the time that Led Zeppelin should be viewed as an artist that couldn't have possibly known about Spirit, just as we looked at that same type of potential with George Harrison and the Chiffons. The reason this is not the case is it was actually determined many years prior that Led Zeppelin had opened for Spirit. Therefore, it is very clear that they were able to know of this band and could have easily known of this work of art. It didn't end up mattering, But that was something that a lot of people who weren't looking too far into the case were mentioning, and it did not hold at all here. This case actually in particular focused on Taurus being an instrumental with line cliches, and Led Zeppelin's Stairway to Heaven being one that had motifs on guitar and flute that were similar to the line cliches, but there was a huge narrative and story arc that took place, making the two very distinctly different songs in that right. So what are some other issues regarding defending copyrights? Some problems you're going to see are that smaller artists are going to have an incredibly difficult time fighting these cases because of how costly they're going to end up being. It makes a lot more sense to settle in most of them in order to prevent high lawyer fees and court costs. And the reason this matters, though, is that means the public view will not have changed on the case. When things are settled on in any part of law, typically public opinion's not going to really be able to get involved. We don't know the nuances of what was discussed behind closed doors. We can make our own snap judgments, thinking if they settled, that means to some extent they thought they were wrong, but we don't know at the end of the day. And in addition, the smaller artist who was infringed upon, potentially infringed upon, will not gain the notoriety that they maybe would have had it been public knowledge that their work was copied or plagiarized to some extent. In addition, this creates issues for precedent. Because of these settlements, there's no court precedent to help act as a roadmap for other cases that come through the court system. A good example of a settlement that happened that also then wouldn't provide much precedent for courts was Vanilla Ice versus Queen and David Bowie. This also was a good example of cost, because Vanilla Ice actually determined it ended up making more sense to just pay for licensing and being able to utilize the song, paying for copyright licensing, versus going through the court systems in order to fight this legal battle. I want to make it clear that's not me making a determination on whether Vanilla Ice or David Bowie and Queen were correct. I'm just merely mentioning the facts of that case. And lastly, I want to touch on why people wait to sue in copyright infringement cases. I hear a lot of the time that people ask, why did artists wait so long? And typically you will have audiences really upset when an artist they really like is getting sued after weeks or months of this song, album, work of art being out. You have to think about it this way. It doesn't make sense for you to go through a copyright case with all the court fees, with all the lawyer costs, everything you're going to need, the potential time that will take, if this song is only made $100, for example. It doesn't make sense to do that. So you're going to want to wait until it's generated enough money that you actually have decent damages to sue for. Otherwise, it's going to be a waste of your time and theirs, and at that point, you're really just fighting for principle, which for bigger artists may be worth it, but when you're really small, you're not going to be able to survive that, more likely than not. In addition, I think that a smaller artist is strategic in waiting for the song to actually gain more traction because they're more likely to get more people to their page noticing them as artists if they wait for the song they're going to file a claim against to actually have some publicity around it. Also, in terms of finances, increasing their potential damages to sue for. So as you can see, copyrights are really messy. Average consumers may hear infringement, and yet experts in the field may disagree. It's a really interesting topic, and I want to dive more into it. I especially want to also bring in the side of streaming and copyrights and also YouTubers, all of that. These are not topics that haven't been done before. I'm not acting as if this is something brand new and innovative, but I'm excited about these topics, and I hope you enjoy them as well, and we can learn a bit more together. I hope you enjoyed this video. I hope you learned something new about copyrights and the music industry as a whole. If you have any questions, or if you think I maybe missed some stuff, things you'd like me to dive in further on, include all of that below, and I'll see you all in the next video. Bye, everyone. If you like these videos, I have more, and there are more coming, so get excited. You should subscribe if you haven't.